Hello, listeners. This is George with the Vanguard. This episode, we're going to be talking about court packing. This is a rather controversial issue, an issue with a lot of insults thrown around, with a lot of acrimony, and also with a lot of facts not being included that should be, with a lot of context that is excluded, and a lot of what I would consider to be, at minimum, misleading, if not outright fake, information being thrown around in order to make partisan points and to obscure the reality of the issues being considered. So first of all, I'd like to start by talking a little bit about the Supreme Court itself, going through a little bit of its history and exploring what its role is in our country's history and present so that we can understand why we would care about packing it and what that would entail. So first we'll talk about when it was created. The Supreme Court was created in Article 3 of our Constitution, which was written in 1787 and ratified in 1789. It was in Article 3, which is an interesting place, because of the first three articles of the Constitution established the three branches of our government: the legislative branch, the executive branch, and the judicial branch. The legislative branch was put first because the legislative branch has the Senate and the House, which comprise the Congress, the Senate being the place that laws are voted on, and treaties particularly are voted on, and then executive appointees are confirmed, and it is selected based on equal representation for states, the House being selected based on population and where fiscal bills are supposed to originate. But the Congress was put first because the legislative authority was considered the heart of the government by the Founding Fathers, so it was given the first place in the Constitution. Then came the executive branch, which had the role of enforcing the rules and laws set by the Congress and also leading, especially on a foreign policy basis. And then lastly came the courts. So really they were put at the end almost. In a sense, these were supposed to be co-equal branches. That's at least the theory that has been carried through in the view of civics put forth by civics education and put forth by many common citizens of the United States. But really, we can see that the Founding Fathers had a very limited role set out for the Supreme Court, both in terms of their writings, but also in terms of where they placed it at the very end of the first three articles of the Constitution. So I think it's important to remember that when we're thinking about what should the authority of the court be in the first place. Now that we've discussed that, we'll talk about who the first justice was, or the first Chief Justice, rather, John Jay. He was a major founding father. He actually was well known for Jay's Treaty, among other things, and he would then eventually be succeeded by John Marshall, who was considered to be one of the most important Chief Justices of the Supreme Court. But now you have an idea of who these early figures were, some of the founding fathers by name, and then also Marshall, who wasn't necessarily a founding father, but was considered a very important figure, at least in the early history of the country, between 1801 and 1835, when he was Chief Justice. The first case docketed in the Supreme Court was Van Staphorst v. Maryland in 1789. Some other famous early cases were Marbury v. Madison in 1803, which asserted judicial review as the authority of the court. Some would argue expanding it beyond what the founders originally intended it to, although there was always some level of judicial review intended, but this decision did assert a broader power than some people were comfortable with, and it also asserted that the court had the writ of mandamus as well as the writ of prohibition. Writs of prohibition, which mean that the court can tell the executive branch or somebody else not to do something, weren't in question. But writs of mandamus, in which the court could tell them to actively do something, that was up in the air for a while, and Marbury v. Madison asserted that the court has that authority too. McCulloch v. Maryland in 1819 asserted the constitutionality of a national bank and effectively appropriated more powers for the federal government and said that states could not tax the Bank of the United States, basically, because Maryland tried to tax the federal bank, which would now be considered the Fed after a couple of iterations. And then the last early case I'll mention is Gibbons versus Ogden, which it was decided in 1824 and said that interstate commerce included interstate navigation, expanding the government's authority, or the federal government's authority specifically through the Interstate Commerce Clause in the Constitution to regulate interstate navigation, so interstate travel along the water and shipping, etc. So next, we'll talk a little bit about the history of the size of the court. So the size of the court changed a few times in our history. It changed first about 20 years in. So between 1789 and 1807, there were 6 justices. That was the original size of the court. Then, actually, between 1801 and 1802, there was an attempt to shrink the court by attrition. There was a bill passed that would have shrunk the court once the next justice left. No justice left during that time, and the law was repealed in 1802, so that actually never went into effect. And then between 1807 and 1837, there were 7 justices through a statutory expansion. Another statutory expansion in 1863 expanded the court to 9 justices, so the size that it is today. Then another expansion this was in 1837. And then in 1863, there was an expansion to 10 justices. So that's actually the largest the court ever was. That only lasted for 3 years, because by 1866, Andrew Johnson, who was nominally a national Republican, but was really a Democrat who had run on a unity ticket with Abraham Lincoln in 1864, was then president because of then President Lincoln's assassination. So the radical Republican Congress did not want him to be able to appoint anybody, so they passed a law to shrink the court by attrition by 1 justice, so that when a justice left, Johnson could not appoint anybody new. They did that again in 1867, bringing it down to 8 justices. But then by 1869, Republican Ulysses S. Grant was back had the Republican Party back in the presidency. So the Congress brought the size of the court back up to 9 justices, and that is how it has remained through today. So we'll talk about what is court packing now, since that's the subject of our episode. Court packing is defined by dictionary.com to be an unsuccessful attempt by President Franklin Delano Roosevelt in 1937 to appoint up to 6 additional justices to the Supreme Court, which had invalidated a number of his New Deal laws. So let's talk about what the New Deal was encountering in terms of trouble and why FDR even wanted to pack the court. Effectively, there were a lot of conservative justices on the Supreme Court appointed by FDR's Republican predecessors who did not approve of his expansion of federal power in the New Deal, and because through 1937, FDR had not had an opportunity to appoint a single justice, so this was again into his second term as president. He hadn't had the opportunity to appoint a single justice. He was very frustrated, and he thought that his programs, in his view, were popular with the American people, and he thought that it was his job to implement all of these major economic programs that expanded the authority, reach, and the responsibility of the federal government, and he found that the court's repeated striking down of many of his signature programs was just not going to work for him. So he tried to advance the Judicial Procedures Reform Bill of 1937. He had some of his allies in the House of Representatives propose it, and then he attempted to get it through the Senate. Needless to say, it was a very controversial idea. People found the idea of adding justices to the court in general to be something that should be done carefully, but specifically the way he went about it was so nakedly partisan that even a lot of allied Democrats with the president of the time, including Vice President John Nance Garner and many of his former activists and allies in the sort of private and political sphere, and then even a whole committee was founded called the National Committee to Uphold Constitutional Government. And this included, by the way, mostly just liberals and Democrats, because they didn't want there to be any accusation that this was a Republican plot to oppose President Roosevelt. And to remember, at the time, there was a very heavy Democrat majority in both houses of the Congress. So the fact that his own party could have passed this without a single Republican vote, and they struck it down. So it's important to see how unpopular this was. Specifically, this bill was going to add 1 justice for each of the justices who was over 70 and a half years old and who wouldn't retire. This was going to be a total of 6 new justices for a total of 15 on the court, with the idea being that these justices might assist the older justices in the caseload and minimize their burden. But really, it was going to be a way for there to be 6 more less conservative justices who would be more amenable to President Roosevelt's legislative program. Basically, this failed very miserably, and that's where we got the term court packing, because that's what people called it then. More broadly, though, the expansion of the size of the Supreme Court, usually in order to add more favorable justices, could be referred to as court packing. And I suppose the broadest definition is one that you could include to lower courts, as in many cases, circuit courts and appeals courts have been expanded in size in the past. And I suppose you could do the same thing in the future if you were having an issue with a particular court that was not standing in favor or not ruling in favor of your agenda as a president or as Congress. You could attempt to expand the size of that court and add favorable justices or judges. So let's take a look at what the whole conversation is today and how the truth and facts fit into the media narratives. There are accusations from both parties against each other regarding this idea of court packing. The Republicans accuse the Democrats of court packing in response to non-responses from both the presidential nominee, Joe Biden, and the vice presidential nominee, Kamala Harris, about the issue. Basically, President Trump, in the presidential debate, and perhaps the only one that will ever happen this cycle, pressed Joe Biden on this issue, and Joe Biden basically said that he didn't think that American people needed to know. Later, he was pressed and gave the answer that the American people don't deserve to know whether he would pack the courts, and if so, what kinds of people he would appoint. And then Kamala Harris was also pressed by Vice President Mike Pence on this issue at the vice presidential debate, and she didn't feel the need to respond, and she didn't really respond to this question. So basically, there's been a lot of lack of clarity from the top of the Democratic ticket, and then there's been explicit support for court packing from people like Representative Adam Schiff, who was infamous from the whole Russia investigation, from Pete Buttigieg, the former mayor of South Bend, Indiana, who made a bid for DNC chair, and then in 2020 this year made a bid for president and failed. And then another failed presidential candidate, Steve Bullock, who's governor of Montana and is now the Senate nominee for Montana's open Senate, or not open Senate seat this year, but the Senate seat occupied by Steve Daines. So the fact that all these Democrats are supporting it makes Republicans see that, okay, they say that they want to add seats to the court or would at least be open to it, and we find this to be just like what FDR tried to do in 1937, and we find it just as unacceptable. Now, the Republicans are also under accusations from Democrats of court packing. These accusations are a little bit more indirect, though, and a little bit different in nature. The Democrats say that because Republicans held many seats on both the Supreme Court and lower courts open over the end of the Obama administration in order for President Trump to fill them, they say that that's packing in that it took away seats that supposedly the Democrats should have been able to fill under President Obama and instead gave the opportunity to fill those seats to Republicans. So they would say that the Supreme Court seat that had been occupied by the late Antonin Scalia was supposed to be theirs because he died in February 2016, and they thought that holding a seat open for what ended up being a little over a year into April 2017, in which it was eventually filled by Neil Gorsuch, was an instance of court packing in that Merrick Garland, President Obama's nominee, didn't get the opportunity to fill or to be in that seat, which would have been what they considered to be normal order. And then additionally, hundreds of Obama-era lower court seats were held open, partly because of slow nominations by the President Obama compared to Trump's speedy nominations, but partly also because the Republican Senate didn't have hearings on many of them and just wasn't interested in consenting to their being filled. So this begs the question, or at least asks us to answer the question, who's right? Could both of them be right? Could neither be right? Or is one party right in its accusations and is one wrong? So I will attempt to answer that question pretty clearly right now. I argue that Democrats are the court packers because they're the ones who are actually trying to expand the size of the Supreme Court, and that's the definition of court packing I adopted earlier. That's the most specific one. So they fulfill that more specific definition. I'd also say that even in the broader definition of trying to expand the size of lower courts, the Republicans don't seem to have any evidence of doing that. What they're doing, and what they've done in the past, is effectively legislative hardball. So the Senate has, according to the Constitution, the role of providing advice and consent to Supreme Court nominees, to lower court nominees, and then also, based on later statute executive branch nominees in many cases. And while the Senate presumably would want to consent eventually to some president's nominees for many of these offices, it doesn't have to. There's nowhere that it says that you have to actually consent to any particular nominee or that you have to do it in any certain time frame. It only says that the Senate's advice and consent is a required step in the process of filling any of these executive agency roles or judicial seats. So I would absolutely say that the Democrats maybe are frustrated that they aren't getting any of their nominees or didn't get through those nominees in the past and may not get them in the future. But I don't see how this is outside of the normal role of the Senate, and it just seems as though the Republicans are hard-nosed and aggressive, but are very committed to getting their nominees approved within the normal tradition. Now, I will say that technically speaking, it is not illegal to pack the court. I mean, there isn't a law that says you can't expand the size of the court. It's been done in the past. But according to the definition of packing the court, which I think is a serious charge nonetheless, because again, the size of the court has not changed since 1869. So this is a very long-standing 151-year norm. And when FDR tried to do it many years ago, it was considered to be controversial. So I think it's still worth saying that this is not only true, but it is something that should be brought up as a major issue to be discussed, that the Democrats are trying to pack the courts. So my ruling is Democrats are guilty of support for packing the courts. Because their party hasn't really in general come out against it, and many of their major figures have either been unclear about it or outwardly supportive. And that Republicans are not guilty of it because their party has not supported expanding the size of the Supreme Court or really any other lower courts, and instead has just filled the court seats that are already there selectively. Georgia's ruling, Democrats guilty, Republicans innocent. And then I will lastly make a pitch for a constitutional amendment on this issue that I think would be particularly helpful in getting rid of some of these concerns for the future. It's called the Keep 9 Amendment, and I would urge you to take a look at it. The text of it is very simple. It is that the Supreme Court shall be composed of 9 justices. Shortest amendment ever, probably shorter than any amendment that ever would be proposed in the future. And very easy for the American people to understand and for our judicial system, our presidents, our Congress to understand, such that there should be no confusion about this issue. It's supported by a bipartisan majority of the public, 62 to 18% in a late McLaughlin and Associates poll pretty recently. So it's clearly popular. It's something that most people agree on. A bipartisan group of former state attorneys general supports the amendment, led by Andrew Miller, a former Democrat and attorney general of Virginia. And it has been proposed in the House recently by Representatives Denver Riggleman, who's a Republican, and Representative Colin Peterson, who's a Democrat. So it has bipartisan support both in former office holders and current office holders, and also even in the general public. This is a very popular issue. It's a simple issue. It's something that I think would get rid of a lot of these accusations and just make it a lot less contentious in terms of Supreme Court and its potential for politicization by packing. I would encourage you to call your congressman and senator because they are the people who can get behind this. We need senators to propose it in the Senate, and we need more people in the House to get behind what has been proposed in the House in order to try to pass it through the Congress, as all 27 pass amendments have been passed. And I make my final pitch on this in that this is the only way to stop court packing. There isn't any way to force the court not to change in size short of constitutional amendment. Because if we pass a law, we're just setting the size of the court as has been set many times in the past. But keep in mind that for the first probably 80 years of the Supreme Court, there were often changes in the size of the Supreme Court. Statute could change it. That means any majority in both houses with the help of the president can pass a change in size, and I don't know if that's a great idea in our polarized times when changing the size of the court with narrow majorities might mean that the court is effectively controlled by the narrowest of majorities won an election at the expense of any influence for the minority. So I really urge you, call your congressman, call your senator, make this a priority, and try to get everyone on record supporting the Keep 9 Amendment so we can prevent this whole issue of court packing that has been so acrimonious in our recent political discourse. Thanks for listening. And tune in later this week for some specials from DJ Trump, and then further on, 4 p.m. Pacific, 7 p.m. Eastern on Mondays for our weekly podcast upload.